Earlier this month, Shasta Scout reported an in-depth piece about the Cottonwood Militia, a community group in rural Northern California that believes in its Second Amendment right to form a citizen militia outside the bounds of Governor Gavin Newsom's control. In response to our story, readers had a lot to say. Many debated whether informal militias are actually legal. So what does the law say? The Second Amendment of the Constitution is not just about having a gun. It also mentions militias. It says that a well-regulated militia is necessary to the security of a free state. Some argue that the term well-regulated means well-organized. Others argue that well-regulated means directly regulated by the government and not civilian people. In addition to the Constitution, the militia is also defined in federal law. Here it is split into two categories, the organized militia, or the National Guard, and the unorganized militia, defined as all able-bodied men aged 17 to 45 years old, with certain exceptions. The first category, meaning the National Guard, is always around to be called up by the president, as we've seen when they've helped distribute vaccines during COVID, or more recently to clamp down on protests in Los Angeles. The second category, the unorganized militia, can also be called upon by the president to defend the United States in the event that we were invaded or there was some kind of insurgency. Like with gun laws, the Supreme Court has empowered individual states to impose their own limitations on the militia. That means that California can have its own more specific restrictions on the militia than federal law. California also has specific laws banning private paramilitaries. Private paramilitaries are defined broadly as two or more people assembling to practice with weapons. Cottonwood militia leaders regularly assemble in groups larger than two to practice with weapons and told Shasta Scout that they consider these California laws illegitimate because they believe they restrict their constitutional rights. The Shasta County Sheriff declined to weigh in on whether or not the Cottonwood Militia could be considered an illegal private paramilitary. But Mary McCord, an attorney from Georgetown who focuses on militia law, told Shasta Scout that we don't get to pick and choose which laws to follow. However, if a state law violates our constitutional rights, it can be deemed unconstitutional in the Supreme Court and then abolished. Theoretically, if the Cottonwood Militia were challenged as an illegal paramilitary group under California law, a court could then decide whether that's true or not, and if moved to a federal court, they could decide whether the law itself is unconstitutional. So far, though, the Cottonwood Militia has been allowed to operate by local and state authorities without challenge.